So the Supreme Court just denied emergency review in a case which challenged a state's ban on so-called assault weapons. So we need to talk about what just happened and essentially what happens now going forward, not just in this case, but some other cases as well. Also want to thank the sponsor of this video, which is My Patriot Supply. I'm not a doomsday prepper by any means, but like many of you, I prepare for the worst case scenarios. That includes stocking up firearms, ammo, water, and also emergency food. One of the companies that I've used to buy emergency food even before they became a sponsor of this channel was in fact My Patriot Supply. Their kits offer about 2,000 calories every day, plus a 25-year shelf life, storage life, so you don't have to worry about that food. And if you're just getting started with emergency food and purchasing this type of item, I'd recommend the 3-month emergency food kits. It's just enough, to actually dip your toes into this type of, preparing. It's one of their best sellers, and it can actually help you decide if you want to go even further. So if you're interested, you can order and you can go to the website preparewitharmscholar.com. And if you use that link that is going to be linked down below in the details section and also in the pinned comment, you can get $200 off and also free shipping. As I mentioned in the intro, in this video, we're going to be talking about how the Supreme Court just denied emergency review to a case which sought for the Supreme Court to step in early and strike down a state's ban on so-called assault weapons. This is kind of an unfortunate development, but not surprising. Essentially, at this point, the Supreme Court, in their track record, indicated that this was probably going to happen. You may recall that the Second Amendment Foundation recently filed for a writ of cert before judgment to the United States Supreme Court in a case that comes out of Maryland, and that was the Bianchi versus Frosch case, or the Bianchi v. Brown case. This writ of cert before judgment was a direct result of the Fourth Circuit en banc panel playing a ton of games, taking the Bianchi case out of the hands of the 3-judge panel in the lower court after it was already sitting for 13 months. And instead of waiting for the Fourth Circuit en banc panel to get the analysis wrong, the plaintiffs in this case, Bianchi, decided to file for a writ of cert before judgment. And that's a mechanism to try to get the case back in the hands of the Supreme Court immediately. But today, the Supreme Court denied immediate emergency intervention in this case. However, there is a sliver of hope for essentially striking down state rifle magazine bans because of some of the other things that have developed. There were also multiple Illinois cases that were sent to the Supreme Court last week at the same conference alongside with the Bianchi case. Those cases were not on the Supreme Court's order list today. Instead, they have been relisted for a conference later this week. That signals that there is more developments in those cases and maybe a little bit more interest in those cases. So we need to talk about what has happened in the Bianchi case, what happens after this denial, and then maybe looking forward what happens with some of these Illinois cases. Now, for those not familiar with this issue and the analysis that happened in the Maryland case and then also the Illinois cases, let me explain generally what is going on. In the state of Maryland identifies certain rifles as so-called assault weapons. Now, this ban was challenged in a Maryland federal district court, and in the complaint, the plaintiffs conceded that their Second Amendment claim was in fact foreclosed, that it could not be brought at that district court level based on a prior Fourth Circuit precedent and decision in a case called Colby. A prior case called Colby challenged Maryland's assault weapons ban, but in the Colby case, the en banc panel in the Fourth Circuit upheld Maryland's rifle ban and found that it was constitutional. They ruled that these rifles are outside the protection of the Second Amendment because they are useful in military service. This whole military use test is still being used by the Fourth Circuit and then now other circuit courts like the Seventh Circuit when they're looking at the Illinois bans. This type of analysis runs contrary to McDonald, Heller, and now Bruen, but some courts are still using this analysis. This case, Bianchi conceded that Colby is the controlling precedent, but that it was incorrect and should be reversed. The district court in this case, Bianchi, ultimately dismissed the complaint for a failure to state a claim. That dismissal was then appealed to the Fourth Circuit, but the Fourth Circuit once again upheld that dismissal, saying that, hey, you can't bring this lawsuit, you can't bring this type of challenge because we've already decided this in Colby. But then this case went to the Supreme Court back in 2022, seeking review of this issue. The Supreme Court ultimately ruled in a different case, a landmark case, called New York State Rifle and Pistol Association versus Bruen. And in Bruen, they found among many things that the correct way to review the Second Amendment cases is to look at the text of the Second Amendment in light of relevant history and tradition. And they rejected the use of tier-based scrutiny, intermediate scrutiny, and then other types of analysis. Now, after issuing that ruling, the Supreme Court issued a GVR, which is a grant, vacate, and remand in this Bianchi case. This case was then opened back up in the Fourth Circuit, and a 3-judge panel heard oral arguments in this case. But then what ended up happening is this case sat for 13 months, nothing developed, and no decision was issued by the 3-judge panel. But then out of nowhere, the 4th Circuit en banc panel, which is the larger panel of judges in the 4th Circuit, took this case out of the hand of the 3-judge panel and said that they were going to review the issue on their own. And they did this likely to avoid any pro tua decision happening in the 4th Circuit. Now, recently, the 4th Circuit en banc panel did hold oral arguments in this case, and those oral arguments showed how the en banc panel is still very much committed to not following what the Second Amendment said or what the Supreme Court has recently outlined in Heller and Bruen, but instead, essentially, of waiting for the 4th Circuit en banc panel to review and decide this case, the awesome team over at SAF, FBC, and the other plaintiffs submitted a petition for a writ of cert before judgment. This essentially is a way to bypass the hearings and rulings of the lower courts and instead go directly to the Supreme Court for an actual ruling on the merits. Essentially, it's a way to jump the line. Now, Maryland, in their brief in response to this writ of cert before judgment, they stated that the language in Heller about M16s means that their outright ban on semi-automatic rifles is in fact constitutional. They argued that the subsequent Bruen decision and the remand by the Supreme Court that Grant vacated and remand in the Bianchi case essentially doesn't mean anything, that Bruen really has no impact on this case. Maryland argued that the remand in light of Bruen was simply just isolated to tiered-based scrutiny, but it did not mean that their ban on AR-15s or these other types of rifles should be brought into question. They also went on to argue that the Supreme Court should not intervene in this case early, because again, it's early, and that they should wait for a merits decision by the 4th Circuit en banc panel, who at that time had already heard oral arguments in the case. And ultimately, I think it's this argument that won out and why the Supreme Court denied reviewing this case. In the order list, the Supreme Court simply stated that the petition for a writ of cert before judgment is denied. Now, what that means is simply that now we're going to have to wait for the merits decision by the 4th Circuit. We're going to have to wait to see what the 4th Circuit en banc panel says. Although I think this is kind of a foregone conclusion by the 4th Circuit, we can pretty much anticipate how they're going to rule based on their track record. And then also, if you just simply listen to those oral arguments, it's very clear what the 4th Circuit en banc panel is going to rule. But we're going to have to wait for that merits decision. But again, like I said, there is kind of a silver lining. Essentially, there is still an opportunity, and we have a bunch of other cases right now that are also seeking review by the court. You had all these Illinois cases that were also submitted to the Supreme Court at the same time with the Bianchi case. But on this order list this week, we didn't see any of those being denied or granted or anything like that. Instead, they have been relisted, and they're going to be in conference once again this week on May 23rd, which I believe is this Thursday. So they're going back to conference. I believe these are all the Barnett cases. You had a bunch of, I think, the NHR cases. You had the FBC cases, the SAF cases. A lot of these Illinois cases have been resent to the Supreme Court, or essentially relisted by the Supreme Court for conference this week. That likely means that the Supreme Court is either going to take a deeper look at some of those cases, or maybe at the very least, there's going to be a dissenting opinion, and whoever the dissenter was, who was not happy with a denial in these cases, wants to write a dissent, so is needing more time, so that's why a relist could happen. Now, I will say that it would be surprising if the Supreme Court is going to grant review to one of those Illinois cases. Remember, all of those cases are on an interlocutory posture. They're all reviews of denials of preliminary injunctions, which, is a much earlier mechanism than even what is going on with the 4th Circuit Bianchi case. So again, I would be surprised if that is the type of case that the Supreme Court wants. Usually they completely avoid those. And also, it would be surprising because if the Supreme Court was going to grant review to one of those Illinois cases, I would expect to essentially see the Bianchi case at least be put on hold and not denied review. So you would expect that if the Supreme Court was going to grant review to one of these cases, they would have at the very least held Bianchi for a decision in one of the Illinois cases. Now, one of the other curveballs that maybe some people are overlooking is the impact that maybe the looming Rahimi case is going to have, maybe the impact that decision is going to have on some other two-way cases. The Supreme Court majority could essentially know that they're going to say something impactful in the Rahimi case, and maybe the application of Rahimi and Bruen, may dramatically impact some of these rifle ban cases and these magazine ban cases. So instead of jumping in now, they might just use the Rahimi case to do some of the work. They're going to deny review to these cases now, issue Rahimi, and then see where the chips fall and let the lower courts kind of deal also with Rahimi. Now, of course, my preference would be for the Supreme Court to simply take these cases and expressly state once and for all that statewide rifle bans and magazine bans are in fact unconstitutional. But that's what's currently happening. The Supreme Court denied emergency intervention in the Bianchi, Maryland rifle ban case, We now are going to wait to see what the Fourth Circuit does, what merits decision they issue. And on the other side, with the Illinois cases, we now are going to see what happens with the relisting. And we're going to be waiting anxiously to see what the Supreme Court does with those Illinois cases. So if we get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.